Hello, everyone. It is good to have you with us today. We're going to wait a couple minutes as folks are coming on board. So you'll hear me do a welcome for the next couple of minutes, since not everybody are the early birds. Well, most Midwesterners are. If something's starting at 5:30, then they're in queue by 5 for sure. But we'll give folks a couple minutes to log on. I'm Jane Klebb. I'm the head of the Bold Alliance. I started Bold, Nebraska back in 2010, and we've since broadened to help pipeline fighters all across the United States. Right now, we're focused regionally on the Midwest to try to stop the risky carbon pipelines, which we'll talk about today, as well as in general pipeline regulations. On the Zoom with me is Paul Blackburn. He's an attorney that does a lot of work with the Bold Alliance. Some of you may know him from the Line 3 fight in Minnesota with Honor the Earth. And Mark Hefflinger is with us as well. He's our communications director at Bold, has been with us, gosh, I don't know. How many years, Mark? 8?
I started in 2013. This is my 10th year.
It's amazing.
Hi, everybody.
So we will get started here in just a minute and appreciate everybody hopping on, especially I know it's in the middle of legislative session where a lot of activists are down in their state capitals pushing for better bills. I will, of course, be touching on a bunch of that kind of stuff today. So we'll get started in just 30 more seconds and I will reintroduce myself. And then I'll be kicking it over to Paul Blackburn. Okay. So we're going to go ahead and jump in. I'll formally introduce myself again. My name's Jane Klebb. I'm head of the Bold Alliance. We started Bold, Nebraska back in 2010. We actually didn't get started as a pipeline fighting group, but quickly after we opened our doors at Bold, we, among many other groups across not only the Midwest, but the country, took on the Keystone XL fight. And we proudly stopped that pipeline shoulder to shoulder with farmers, ranchers, climate advocates, tribal nations, and national environmental groups. We all had a part. It took activists, it took tribal leaders, it took landowners that were directly in the path. It took lots of lawyers. It took lots of policy experts. And of course, it took 2 presidents, President Obama and President Biden, who both rejected the Keystone XL pipeline. We learned a lot of lessons on that pipeline fight. And the top lesson for us here at Bold was that these fights are won not at the federal level. These fights are won in communities all along these pipeline routes. There's a saying that the people who are most impacted and who would experience most of the pain should be at the table for the solutions. And that's exactly our philosophy here at Bold. It was all those fighters along the route, those county commissioners and those elected officials who really made a difference in this fight. So for tonight, we're actually going to talk about a critical tool in a toolbox to fight pipelines. And that is making sure that you have good, strong local ordinances when it comes to pipelines. When we start going and giving presentations to county commissions, what you will hear, and I'm sure what many of you have heard if you've gone in front of your county board or your planning and zoning board, is the pipeline company comes in before or after you and says, anything that they just told you can't be enacted. All of that is what they say preempted by federal law. Usually that is a lie. And they don't just say it, and they don't just threaten lawsuits, the big oil or the big pipeline corporations. They actually take counties to court, even though a lot of these zoning regulations are absolutely legal for them to implement. In fact, in Iowa and South Dakota, right now, several counties who enacted pipeline zoning around carbon pipelines are being dragged into court by Summit and Navigator Pipelines, the very pipeline companies that tell all of us that they want to be our good neighbor and that really they're in this to save the planet. So tonight, Paul Blackburn, who is an expert on pipeline regulations, who is a lawyer with the Bold Alliance, is going to go into detail about what counties can and cannot do. Mark Heflinger, our communications director, is going to be putting some links in the chat. One of which is we created this carbon pipeline zoning guide book and landowner guide for landowners and county commissioners. It is full of really good information that you can adapt for your state. There's sample ordinances in there. There's memos from the Pipeline Safety Trust, which is a great ally and education resource on what counties and states can do to regulate pipelines. For me, the bottom line to remember is that pipeline companies will do everything to make sure that they can build their pipeline as fast and as cheap as possible. It's our responsibilities as citizens, even if you want to support a pipeline, it's our responsibility to make sure that that pipeline, if and when it's built, is built in not only the safest way, but is built in a way that is going to protect the land and the water, and most important for us, protect property rights of folks who live along the route as well as tribal nations. So with that, I will hand it over to Paul Blackburn, who will get into the presentation, which is about 20 to 30 minutes long, and then we'll have plenty of time for questions.
Thanks, Jane. Yeah, again, my name is Paul Blackburn, and I've been working on pipelines since about 2009. Before that, I worked in a variety of different kinds of environmental fields and law. I have experience in project development for the industry side, including project development in coal-fired power plants, trash burners, renewable energy projects, and other sorts of things. So I have worked not only for nonprofits, but also for the industry. And so what I'm going to talk about here is the concept of preemption. I'm going to share my screen of a presentation here. So let me get this going. And looks good. Okay. All right. Okay, so what we're going to be talking about tonight is primarily what's called federal preemption. There's also state preemption, and I'll get into a bit of that at the end. But most of the arguments that you're going to hear relate to federal preemption. Okay, so what is preemption? Well, preemption is the concept of hierarchy in laws. So that means there can, you can have an area of law regulated by the federal government, by state government, by local governments, county or city or township. And, the question is which law prevails when there's a conflict between them. And the general rule is that the federal government can preempt state and local laws, and the state government can preempt county and municipal laws. So, it's the feds on the top, the states in the middle, and the county and cities are below the states. That being said, this is not an absolute hierarchy. There's some areas of law where they share jurisdiction for a variety of reasons. So you'll have some aspects of an issue regulated by the feds, some aspects regulated by the states, and some aspects regulated by local governments. And so this area can get somewhat complex. But nonetheless, it's there, and as I'll talk about during today's presentation, there's certain aspects of pipelines that county governments and municipal governments cannot regulate. There are other aspects of pipelines that they can regulate, and how that works is somewhat detailed. But I'll walk you through the general rules and provide sort of a cheat sheet at the end, so you can get a sense of how this set of law works. Ultimately, whether something is preempted by the federal government depends on legislative intent. So if the Congress says that they want to preempt state and local laws, then that's going to hold up. But I'll talk about that in a second. So let's see. So yeah.
Sorry, can you maximize the slides? We just had a comment that it was a little hard to read because you can see like the upcoming slide as well on your screen there. Sorry.
I'm gonna have to unshare and then reshare, I think. Let me try this again.
No worries.
Okay. Is that better?
Yes.
Okay.
Thank
So
you.
this,
Oops. I accidentally muted you, Paul.
okay, there we go. We'll get this done. There's three kinds of preemption. There's express preemption, and that's where a legislature says that a law is going to is the lower level law is going to be preempted. So sometimes the U.S. Congress will say a certain area of law is preempted, and that is just simply how the courts are going to hold it. That express preemption means exactly what it says. If Congress says something's preempted, it is. There's also conflict preemption, and that exists when there's no express statement in a federal law about preemption, but if there's a conflict, you can't comply with both federal and state law at the same time, then the federal law is going to supersede the state law. There's also something called field preemption, and field preemption is when federal law, area of law, doesn't necessarily expressly say that an area is preempted, but it's the federal law is so extensive that the courts find there's no room for state or local regulation. These are somewhat technical definitions, but just to give you a sense, it doesn't have to be Congress expressly saying something. There can be preemption just because of conflicts or because of a sense of what Congress wants to do. Yeah, so there's three. Let me see if I get this. Anyway, so there's three laws that apply, that are going to apply here. One is the Pipeline Safety Act. One is the Natural Gas Act. Let me see if this got out of order somehow. Sorry about this. Yeah, okay. Well, there's three laws that apply here. There's the Pipeline Safety Act, there's the Natural Gas Act, and there's the Oil Pollution Act. And I'll talk about each of these. Under the Pipeline Safety Act, the preemption provision is in section 60104C. And this provision says it's different for intrastate and interstate pipelines. I'll talk about that in a second. So for intrastate, meaning pipelines that are not used in interstate commerce, a state authority may impose higher safety standards on a pipeline. But let's take a second here and unpack that. When it says a state authority, it means that the specific state agency that's delegated by the federal government to regulate pipelines to a limited degree under the Pipeline Safety Act. So a state authority here doesn't mean any state agency or any local or county agency. It's only the specific state agency that has authority over intrastate pipeline facilities. So that's, so there is some wiggle room on intrastate pipelines, but then if you look at the next sentence, it says the state authority may not adopt or continue to enforce safety standards for interstate pipeline facilities or interstate pipeline transportation. So that means that if it's an interstate pipeline, meaning it moves a product in commerce between two states, then no state authority can adopt or impose safety standards. So, again, there's certain kinds of intrastate pipelines that a state government can impose higher standards on, but for interstate pipelines, they can't. So again, in the definition here, whether something is an interstate pipeline is whether it's moving interstate product in interstate commerce. So a pipeline can be 100% inside of a state, but if it's connecting to other pipelines that are then moving that product through to other states, then it's probably going to be an interstate pipeline. In any case here, the proposed Summit, Navigator, and AD and Wolf pipelines are all interstate pipelines. Therefore, no state may adopt or enforce safety standards regardless of their consistency with federal law. So, these big CO2 pipelines are generally going to be interstate pipelines, and that means that the Pipeline Safety Act preempts safety standards. We'll talk about that more in a sec. Anyway, here's the slide I wanted to get to. So yeah, there's these three laws. The Natural Gas Act, it regulates the development of interstate natural gas pipelines. And the Pipeline Safety Act regulates safety standards for interstate and intrastate pipelines. And the Oil Pollution Act regulates pipeline company planning and spill response to pipeline oil spills, oil and petroleum spills. And each of these has an effect on preemption, and any preemption analysis needs to analyze all three of these. Any preemption analysis of a county ordinance needs to analyze all three of these federal statutes to make sure it's not violating any one of them. Because if it violates any one of these, then that ordinance may be preempted. Okay, so the Natural Gas Act, well, it regulates all aspects of interstate natural gas pipeline development, including routing, environmental review, mitigation, and eminent domain. So that means that, and again, this is the Natural Gas Act, which shouldn't be surprising then, does not regulate carbon dioxide pipelines or oil pipelines. It applies strictly to natural gas pipeline development. And the federal courts have clearly held that even though the NGA does not have a express preemption clause, that all state and local permitting of interstate natural gas pipelines is preempted. So a county ordinance must not attempt to regulate almost any aspect of interstate natural gas pipelines. It's a pretty hard and fast rule about that. So if your ordinance mentions interstate natural gas pipelines, be very careful and probably to not regulate them. Counties may not require construction or zoning permits for any of these interstate natural gas pipelines. The Pipeline Safety Act, again, it regulates, it applies to safety, not to construction permitting. It just has standards for how pipelines are built. It's kind of like a building code for pipelines. Just the way a building code for a house would say how big the 2x4s there are. I mean, what kind of lumber they have to use and how close the 2x4s are together, and the kind of insulation and the kinds of electrical, equipment and pipes and whatnot that go into the house. The Pipeline Safety Act is kind of like that. It tells pipeline operator and developer how to build its pipeline and how to operate this pipeline. So it relates to things like how deep the pipe is buried, how thick the steel has to be, how the pumps are designed, where the valves have to be located, where there's called cathodic protection to stop corrosion, what that has to be like. Basically anything related to the physical design, construction and maintenance or operation of any of these kinds of pipelines is regulated by the Pipeline Safety Act. Now, the federal courts have clearly held that state and local governments may not regulate in the field of pipeline safety. So, except, like I said, for this limited exception for intrastate pipelines, but as a general rule, a county should not regulate in the field of pipeline safety. And that's, again, for natural gas, hazardous liquid, or carbon dioxide pipelines, for all types of these pipelines. But the question is, what are safety standards? Because the pipeline industry always says that means that anything related to safety is preempted. Absolutely anything related to safety is preempted. And that's not what the law says. The Pipeline Safety Act says that that adoption and enforcement of pipeline safety standards is preempted. And so a safety standard is defined by 49 U.S.C. 60102A2, and there's basically three important elements to this definition. The first is that it applies to pipeline transportation and for pipeline facilities. Second is that it applies only to the owners or operators of pipeline facilities. That means that PHMSA cannot issue regulations that improve pipeline safety that would apply, for example, to local governments. The PHMSA doesn't have any authority to do safety standards for example, adjacent properties that could be subject to local zoning. It applies only to owners and operators of pipeline facilities. And then they may apply to the design, installation, inspection, emergency plans and procedures, testing, construction, extension, operation, replacement, or maintenance of pipeline facilities. So, if it's a standard related to any of these this list of elements, counties may not regulate in that area. So, for example, I underlined emergency plans and procedures. A county may not regulate an owner or operator of a pipeline facility with regard to its emergency plans and procedures, full stop. Okay, so that means that a county may not tell a pipeline operator, with one exception I'll talk about in a bit, how to respond to an emergency, what kind of personnel it needs to have, what kinds of emergency response equipment it needs to have. All of that, a county may not regulate under federal law. But if it's related to the design, like how thick the steel is, or installation, meaning how deep the trench is, or what kind of fill to put on top of it, or the inspection, testing, construction, extension, operation, replacement, maintenance of pipeline facilities, counties have to stay away from all that stuff. But on the other hand, the Pipeline Safety Act also makes clear that PHMSA is not authorized to establish safety standards for route determination or to determine a route. So that means that PHMSA cannot issue safety standards for looking at comparing two different routes and deciding which one's safest. They can't do setbacks. PHMSA can't issue setbacks. It's not within their jurisdiction to issue setbacks. PHMSA can't pick a route. PHMSA can't look at a variety of factors and then pick a route. PHMSA has to keep their hands off of route issues entirely. That's why entities such as the Iowa Utility Board and South Dakota Public Utility Commission, North Dakota Public Service Commission, can determine the route of oil and gas pipelines, oil and CO2 pipelines. Because again, natural gas is regulated under the Natural Gas Act. Interstate natural gas pipelines regulated under the Natural Gas Act, and there counties cannot route a natural gas pipeline, but counties may route oil and CO2 pipelines. And again, this is because the Safety Act simply says this chapter doesn't authorize the Secretary of Transportation to prescribe the location of routing a pipeline facility. So the authority under the Pipeline Safety Act to route a pipeline facility remains with the states, and if the state hasn't taken on the routing responsibility, then it still remains with local governments. And the question often comes up: may a state and local government consider safety in routing? So could a state government look at two different routes and see which one has more sensitive lands or sensitive facilities like nursing homes and hospitals, schools, and decide which route is safest? And the answer, according to 3 federal courts so far, is that yes. A state government could look at the risks of two different routes and pick the safer one. And the reason there's a lot of different reasons why that's allowed. But first off, as I said, if the PHMSA can't do that. So if PHMSA can't do it, and the pipeline industry always argues that the states can't do it and local governments can't do it, then no agency could do it. And there's no indication that Congress wanted to prohibit consideration of safety in routing by all agencies. Congress has never said that. So also the federal safety standards are, like I said, they're like a building code, and just like a city or county could determine whether a building should be built, in a downtown, more urban area, or whether it could be built on the edge of town. The actual design and building code for the building be the same building built possibly in 2 different locations, but the building code would generally be exactly the same regardless of its location. So the same thing is true for pipelines. State could pick Route A, and based on non-safety factors, or could pick Route A based on safety factors. And in either case, the same exact federal standards would apply. The trench would still be as deep, the pipe steel would still be just as thick. The pumps would be the same, maybe, so things would be basically essentially the same. So federal law is, Pipeline Safety Act is route neutral. Doesn't really matter why a state picks a route. It can apply fully to any route that's chosen for any reason. The other thing that the courts have said is that the field of pipeline safety is separate from the field of pipeline routing, meaning that the Pipeline Safety Act preempts the field of pipeline safety, but the field of pipeline routing is an entirely different analytical process. And the federal courts have recognized that. And so that process remains entirely within state jurisdiction, and the feds have no jurisdiction over routing. But so I want to get back to this emergency response question. And there's a relatively bright line here. So like I said before, state and local governments may not regulate pipeline company emergency response plans because that's expressly included within the scope of the Pipeline Safety Act. But local agencies have complete jurisdiction to respond themselves and to do their own response planning for their own emergency responders. And why is that? Well, because remember when I said that the Pipeline Safety Act applies to owners and operators of pipelines? So PHMSA has issued rules about how pipeline owners and operators do emergency response, but they can't issue rules to local government agencies about how their emergency responders will respond to a pipeline rupture. So basically the rule here is that counties shouldn't regulate pipeline owners and operators with regard to their emergency response plans, but they can regulate their own agencies and first responders with regard to how they respond to a plan. So a lot of counties seem to want to think that there's one emergency response plan, and the truth is that under law there needs to be two. There needs to be a company emergency response plan, and there needs to be a county emergency response plan. And the pipeline companies don't have any jurisdiction to tell the police and firefighters and emergency medical services how to respond. At the same time, the police and firefighters and emergency medical services don't have the jurisdiction to tell the pipeline company how to respond to rupture. So the agencies need to have a separate emergency response plan under law from the company plan. But at the same time, federal law requires that the company communicate with local emergency response agencies and that they share information and coordinate these two emergency response planning processes. And this is rational because pipeline company knows how to respond, how their people need to respond, but they're not police, they're not firefighters, they're not emergency medical services. So they're there just to respond technically to trying to stop the pipeline from leaking if they can and fix it afterwards. That's what company emergency response people do. They're not going to rescue people. They're not going to provide medical services. They're not going to keep people out of danger. They're not going to block off the area necessarily. That's not their jurisdiction. So there just needs to be two separate plans, and the county has full jurisdiction is to extent limited by state law to determine how their police, firefighters, and emergency medical services are going to respond. The Oil Pollution Act, though, has one big exception to all this. It regulates all aspects of oil and petroleum spill response. So, when the Keystone Pipeline, for example, ruptures, the response is regulated by the Oil Pollution Act. And it expressly states that it does not preempt state and local regulation of oil and petroleum spill response. So that means that state and county or local governments may impose higher standards for spill response on an oil or petroleum, gas, diesel pipeline. But again, this special exception applies only to oil and petroleum pipelines. So again, a county for a natural gas or CO2 pipeline cannot impose higher emergency response standards for an oil pipeline. It can. So that's sort of what they can't regulate, but talking about what they can. So the list of things that general areas that counties may regulate includes routing for hazardous liquid and CO2 pipelines, not natural gas, but hazardous liquid and CO2. Company emergency response plans, just talked about that, are only for oil pipelines. County emergency response plans for all types of pipelines construction and operation mitigation aesthetics for hazardous liquid and CO2 pipelines. So that means, how to store the soil, weed elimination, replanting, tree removal, noise at pump stations, how pump stations are built and their aesthetics. All those kinds of things are subject to county regulation. And then also counties can regulate post-abandonment mitigation for hazardous liquid and CO2 pipelines. So what does that mean? After a pipeline is stopped its commercial operation, it's abandoned. And abandoned pipelines can have really significant effects on landowners. They can, if they start rusting through, they can serve as drainage pipes essentially, and they could drain lakes fairly quickly if from high to low location, if they're starting to rust away. They can cause sinkholes, they can collapse under heavy equipment, but on the other hand, there's ways of stopping this from happening. They're expensive, but a county could impose the pipeline abandonment plan for hazardous liquid and CO2 pipelines. And then also counties may be able to control for hazardous liquid and CO2 pipelines, may control the depth that a pipeline is buried through what's called the level of cultivation definition. So federal law for hazardous liquid and CO2 pipelines says that that pipelines have to be installed below the level of cultivation, but then federal law doesn't define what level of cultivation means. And that means that there's an opportunity for state and or counties to define this level of cultivation, which makes sense because level of cultivation can be radically different between, dryland prairie out west and, saturated soils in northwestern Iowa. The level of cultivation may be very little in some areas and over 10 feet deep in other areas. 2 states have issued level cultivation rules, Minnesota and New York, and they've never been challenged in court. So, but again, it has to be done not by specifying a general depth of cover for pipelines, but by defining the level of cultivation and then having that be applied. Here's the cheat sheet I talked about. So on the left-hand side, there's a list of different kinds of policy issues. On the top, there's different kinds of pipelines. And if you look at, go across, like the first one, pipeline safety standards, natural gas pipelines, it's preempted. The red means it's preempted, the green means it's not preempted. So going down natural gas pipelines, pipeline safety standards are preempted. Route and location setbacks are all preempted. Operator emergency response plan is preempted, but counties can do their own response plans in the event of a natural gas pipeline rupture. But again, construction operation mitigation is preempted, depth of cover is preempted, and post-abandonment mitigation is preempted. So natural gas pipelines, there's not much counties can do about them. But oil pipelines, you can see there's a lot more green. They, for local, if states are not regulating pipeline route location, counties can do it. They can for oil pipelines, they can regulate pipeline operator emergency response because of the Oil Pollution Act. Counties can regulate county emergency response, can regulate construction and operation mitigation, can regulate this level of cultivation, and they can regulate post-abandonment mitigation. And CO2 pipelines, the only difference with an oil pipeline is that the county cannot regulate the CO2 pipeline operator's pipeline emergency response plan. So that's, I put that in there because there's a lot of detail here. And one of the things you have to realize is that when you're talking about preemption, it's like threading needles. There are many things that counties can do, but it's very important how an ordinance is written. If it's written poorly, it can be preempted. You can do a lot, but you just have to be really smart in how you're drafting an ordinance. And this area of law can be quite complex. And there's a lot of detail and nuance to it. So I'm giving you, sort of high level guidance here. But it's something to be aware of, this complexity. And then also, even if federal law allows county regulation, the state law may preempt a county ordinance. And so, for example, an example of that is that the state of Minnesota has said for pipeline routing, that all county ordinances are preempted by state law. So in Minnesota, the states, counties have very little authority over any pipeline routing because of state law. Other states are different, and I'll talk about that in a second. But as a general rule, when you draft an ordinance, seek professional legal advice on that ordinance, and not just from the pipeline companies, because they're going to just sling a bunch of baloney about that. But seek advice from like me. That's what I'm hired for Bold to do, or some of the other attorneys I work with, in this area of law. And we can just walk through your proposed ordinance and make sure that it passes muster, and keep it from going into court, or if it goes into court, to give it a much better shot at winning in court. So that's what I got in federal preemption. But I just wanted to say with state preemption, it really does depend on what state law says. So in South Dakota and North Dakota, what the law essentially says is that counties may pass ordinances, but the Public Service Commission or Public Utility Commission can supersede them if they find that the ordinance is unduly restrictive. In North Dakota, there's some very specific timing requirements for when counties have to submit their ordinance requirements. In South Dakota, they don't have the same timing requirement. In North Dakota, the state routes pipelines, and so there's there's less ability for counties to control the route. In South Dakota, the Public Utility Commission does not route pipelines, which means that it's up to the counties. If any agency is going to route that CO2 pipeline, it's going to be the county or nobody. So it's important for counties to consider how to set up their routing ordinances through their zoning structures. In Iowa, it's a little bit more complex because the counties have authority under the state home rule constitutional provision, but there's also state law precedent that where a county ordinance directly conflicts with state law, then it's going to be preempted, meaning since the IUB controls route, if there has to be sort of a cooperative relationship between the county and the IUB, and so the laws need to deal with that. And like for the Shelby County ordinance was written very much with the idea of having the county and the IUB rules dovetail with each other. And other states, like I said, Minnesota does essentially preempts almost all county action, and the other state we work in is Illinois, and frankly, I'm not entirely sure off the top of my head right now exactly how it is in Illinois, but this is where what I do when I'm not certain about what a law says in a particular state is I talk to an attorney who's licensed in that state, and we figure out what the county's rights are. So that's what I have. And again, counties can do a great deal, and we really strongly encourage them to take certain actions, particularly in states that don't, for example, route pipelines, or in states that have very weak mitigation rules, or that don't have any requirements for pipeline abandonment. So, as Jane said, these pipelines, if they're built and when they're built, they should be built to the highest standards, and they should be built to protect landowners, because after all, the landowners are going to, be taken in the chin to get these pipelines across their property. The least the pipeline company can do is to, build them well to make sure that the landowners are made whole during the construction process and made whole, after the pipelines are abandoned. So that's what I got, and I'm very happy to answer any questions, and I really appreciate everybody being here today.
Thanks, Paul. If you have a question, there's already some in the Q&A, which I'll start to say out loud so Paul and Mark and I can chime in for the answers. If you have a question, you can just click on the Q&A button, or if you put it in the chat, Mark may catch that also, but you can just click on the Q&A on the bottom there. So the first one is CO2 pipelines will require very expensive all electric EMS vehicles. Who would pay for those? So the electric vehicle piece comes in because when a carbon pipeline explodes, your regular gas ignitions obviously need oxygen, the carbon kind of takes that out of the air like we saw in Mississippi. So that's where that question comes in.
Sure. So that's a good question because we can apply what a county can and can't do. So a county could not require a pipeline company to have electric vehicles, at hand, because that's the pipeline company's equipment and response. What a county could do is require that its own EMS, firefighters and police have access to electric vehicles. And then it could charge the pipeline company a fee to pay for those vehicles, because first off, regulating their own, having their own equipment is, the Public Safety Act doesn't tell, counties what kind of equipment to have. Doesn't mean there's no requirements about that at all. And requiring that a company pay for that equipment is not the same thing as imposing a safety standard on that company for what its emergency plan has and how it operates in response to a spill. It just says that, for the privilege of working in this county, you're going to help pay, or operate in this county, you're going to help pay for the emergency response equipment. So it has to be done through a fee structure. So, the county would buy the equipment and then essentially charge the company to pay for that equipment.
And several counties have begun to have those conversations where just like for a pipeline, especially if they're in a rural community, they would want to have a trailer of specific emergency response equipment for their county emergency response teams, their firefighters, EMS, et cetera. And so very similar to what Paul said, you can build that into an agreement with the pipeline company and put it into an ordinance. So any pipeline company after that would have to follow the same process as well. Charles asks, an operator emergency is preempted for CO2, but not for oil pipelines. What's the reason for the difference?
Right. The reason for the difference is that the Oil Pollution Act contains, I think, 3 or 4 different provisions that expressly state that federal law does not preempt county or state regulation of spill response for an oil pipeline spill. And I believe the citation is 30 USC 1321 sub O. And it just simply states that, that state or local governments may impose higher standards on oil pipelines for spill response. And you see that these kinds of laws have been implemented all over the country. The best state oil spill response program in the U.S. is Washington State's, probably because of the risk of oil spills into Puget Sound. Washington State has a very extensive state program that requires state emergency response plans. It has very detailed standard requirements for how an operator responds, the equipment they have to have, where the equipment is stored and located, the training that they have to go through. It provides, provides the public with emergency response plans and allows the public to comment on these emergency response plans. And that law has never been challenged by any pipeline company or oil tanker company or any oil company, because it's just very clear that federal law, Oil Pollution Act, says that it doesn't preempt higher state or local standards. But again, the Oil Pollution Act applies only to oil and petroleum pipelines, gas, diesel, jet fuel, things like that. Doesn't apply to natural gas or carbon dioxide pipelines. So go hog wild with whatever you want for oil pipelines. Just don't try to do the same thing with natural gas or CO2.
And Paul, this is related. Kathleen almost has like a follow-up question. Let's say a county puts in their ordinances that for their county level emergency response, they're going to need this equipment. They're going to charge the pipeline companies in their county jurisdiction to provide that equipment, and even require a yearly training, which I know some counties have discussed as well. So that training is ongoing. Obviously, you get new firefighters in EMS all the time. But if a pipeline company refuses to do that, if they refuse to pay for the EMS equipment, for example, what does a county do? Is there some type of then fine that they would have to impose inside their ordinances?
Yeah, the counties would do this kind of planning probably through either their emergency response. There's two different areas they could do it through: the emergency response planning, which like in Iowa is, I think it's 29C or something like that. Anyway, every state has an emergency response planning statute. Each of these statutes are more or less similar to each other. They all require that local governments, county governments, set up emergency response, committees or commissions. And so all this, all these state governments allow counties to establish emergency response programs and to prepare emergency response plans for both natural and human-caused disasters. And some states expressly say that they can charge fees. Other states don't, but they imagine they may be able to charge fees anyway. And so, under this emergency response planning laws, essentially just becomes a fee imposed under that law on a hazardous facility. They could also do it under their zoning authority and have the emergency response process be part of the zoning commitment, possibly. Depends again on state law and how this works. And then it would just be, just like many places have development fees. So if a developer wants to build a mall, they have to do improvements for the roads coming into and from the mall, and they have to pay for sewage improvements and all those kinds of things. The development fees are pretty common in zoning efforts. And this is sort of the same thing. If you want to put a pipeline through, well, you have to pay for the emergency response costs. You have to pay for our permitting costs. You have to pay for, the cost we have of emergency alert systems for our citizens. There are CO2 pipeline CO2 detectors, just like the carbon monoxide detectors, which many of us have in our house. You can buy a similar little white box that plugs into your wall that detects carbon dioxide. Well, a county could, provide one of those to each residence within a mile or two of the pipe, and then just charge the pipeline company to do that. Again, the county's not telling the pipeline company what's in its emergency response plan or what it has to do with regard to notification of citizens. It's just saying, the county, we're going to do all this. But rather than having us pay for it, we're going to just charge a reasonable fee from this pipeline company to reimburse us for the costs for the right of doing business within our county.
Thanks, Paul. The next question I'm going to read, but I think I know what the fellow folks are trying to ask. So they ask, why do pipeline builders, utility entities, why are they allowed to break federal laws like wetland protection, endangered species, clean water? It seems like the corporation's EIS usually gives the jobs lie, but why is that a legal excuse? Is it because of the Commerce Clause? So I think they're getting at, sometimes these pipelines are required to do an EIS, an environmental impact statement. Not all pipelines are. And they usually seem to get around following a lot of laws that you would think would stop a pipeline or make a pipeline go around certain areas because they often use the jobs or Commerce Clause line.
Yeah, and that's a complex question because how they get around a particular law has to do with that particular law and the particular circumstances. And, it would probably be multiple days of presentations to talk about, for example, how they get around wetlands laws and how they get around, certain kinds of environmental review. So I can't really go into that in detail here, but it's true that they've managed to avoid a lot of regulation. I mean, it's relatively rare for a pipeline to have to do with a federal environmental impact statement. And there's a whole lot of underlying legal reasons for why that's the case. There are some that do. Usually it's tied to a border crossing, like with Keystone XL. The reason they had to do a federal environmental impact statement was because of the presidential permit. Or for DAPL, they had to do an environmental impact statement because of crossing the Missouri River and impacting tribal lands. But for Line 3, there wasn't a federal environmental impact statement. Instead, there was a state of Minnesota and a separate state of Wisconsin environmental impact statement for Line 3. But and the reasons the way they get out of doing any kind of federal environmental review in a place like Minnesota is relatively complex.
And I'll just say, when a pipeline company has to do something at the national level, which is not the case for CO2 pipelines. And so I know a lot of folks are on the Zoom tonight because we care about potential CO2 carbon pipelines coming through our communities. The federal laws around carbon pipelines are catching up to the carbon pipelines, and PHMSA has a rulemaking process that they've announced. You could see new rules, but it'll probably take a year, maybe two. And there's not a national EIS process that carbon pipelines have to go through. If you ask folks on this call, we would say that they should be going through a lot more stringent, rigorous review before all of us are seen as the guinea pigs for them.
Yeah, I'll just add that, if I can just add.
Sure.
Federal environmental review is triggered by an approval of some sort. So some agency has to approve something for the National Environmental Policy Act, which is the law that requires environmental impact statements to kick in. And with pipelines, the industry has worked very hard to avoid having agencies do approvals in any formal sense. So, for example, the Pipeline Safety Act is implemented by the Pipeline Hazardous Material Safety Administration, or PHMSA, and it's written so that there's not a single formal approval that PHMSA makes for a pipeline before it goes into operation. So nothing that PHMSA does triggers National Environmental Policy Act, triggers an EIS. For the Army Corps of Engineers and the wetlands permits, what they've done is they said, well, each individual water crossing is a separate permit. And since each individual water crossing is just one smallish place typically, that individual place doesn't trigger an environmental impact statement. Even if there are hundreds of water crossings, as happened with Line 3 in Minnesota, they don't consider the cumulative impact in determining whether an environmental impact statement is needed. Instead, it determines whether there's one crossing that's so significant that it deserves an environmental impact statement by itself. And that's been upheld by the federal courts, unfortunately. So I mean, they've been fighting to limit how much environmental review is done for these pipelines for a long time. So in some places, if the pipeline is, for example, just through North Dakota, South Dakota, and Nebraska, and it didn't go across an international border and didn't cross, one of the major rivers, it probably wouldn't have an environmental impact statement done for it.
Exactly. Susan asks, who determines the level of cultivation? That would be done at the county level. So if a county decided that they were going to do some zoning regulations around carbon pipelines or even oil pipelines, they would determine what the level of cultivation is. Paul,
yeah. I mean, it could be it was county or the state. Like I said, the federal law says that the pipelines has to be below the level of cultivation, but then it doesn't say what that term means. And I checked as thoroughly as I could using, Westlaw search engines for the term level of cultivation within federal law, and I didn't find that it's defined by the USDA or anyplace else. And again, that kind of makes sense because the level of cultivation can change radically from one county to the next, or from one state to the next. So I believe that Minnesota's law says that the level of cultivation is at 4.5 feet, which means that pipelines, are not buried at the standard 36-inch depth within in Minnesota in agricultural lands, but instead it's buried at 4.5 feet. And I forget what it is in New York State, but they have a similar law. So, again, it could be the state, but if the state hasn't done it, then the county could just do a resolution that says in this county, the level of cultivation is determined by either a set specific amount, like 4 feet or 5 feet or 10 feet, or by, for example, reference to the tiling in the county. It needs to be below the level of tiling. Cultivation includes tiling, therefore the level of cultivation should be below all tiling, something like that. I think that landowners, farmers, and county officials will have a relatively good sense of what level of cultivation practically means, and as long as they're not playing games with it, but instead defining it honestly for that county, there's a good chance that a federal court would say, well, this is what the level of cultivation is here, and so that's what you have to be below.
David, if you're still watching, I asked you just to clarify your question, just so I can make sure I'm asking the right one about the federalizing of a pipeline. So I'm going to go to these two other ones that we have. Susan asks, if a county's considering drafting an ordinance, is there a basic fee for you to review the proposed ordinance? So Bold, and Paul does work with Bold. This is a service that we provide counties. Now, counties obviously will need their own local legal counsel. And counties normally do have a county attorney and an expert attached to their planning and zoning board, for example. But Paul has reviewed probably more county ordinances than he would like to admit at this point in the year that we've been working on carbon pipelines. And so if you are a county administrator, a county board member, or a landowner, an activist that's working in a county and want to see sample ordinances or want Paul to review a ordinance, we're happy to do that. Mark can put his email, Paul's email back in there. We do that as a service, as a public education service of what we do at Bold. Part of what we do is educate the public, educate counties, educate states on what you can and cannot do when it comes to pipelines.
Yeah, and I would say in terms of the county fee, it depends a bit on how the county sets its fees already. But you can look at state models for fees. So for example, Minnesota has a fee where the state has to estimate how much the cost to do a full environmental impact statement and add that in, the cost of the Public Utility Commission review process, the cost of state expert witnesses and things like that. So, the state's completely reimbursed and it estimates what the cost is going to be. If they charge the public company too much, they reimburse the overage. If they didn't charge enough, they can file a supplemental fee. So there are ways of doing a fee that can pay for even relatively complex county review processes. Or the county could just have a fairly simple flat fee. They could just say $50,000 or $100,000. And look, folks, these CO2 pipeline companies are going to get so much money through the Inflation Reduction Act. The three pipeline, ADM, Wolf, Navigator, and Summit combined are going to be getting like 3.3 to 3.5, up to 3.3, $3.5 billion per year, with profit margins in the 100 to 150% range. They have so much money that you should not worry in the least about, charging them to help pay for these expenses. They want to offload the costs onto you. They're getting so many free federal dollars that they should be generous, and you should just charge them what you really need. Again, you don't want to be excessive. Some counties want to impose extremely high fees without any rational basis. That could run into state law issues. But as long as you have a rational basis, we want to pay for all these elements of the application that are all important services for our citizens, and they're all well-grounded, firmly grounded, then they're rational fee. It's a rational fee structure, and it should be upheld, as not being simply obstructive or, in violation of the Commerce Clause or in violation of state taxation rules or fee rules.
Exactly. We have two more questions, Paul, and then we're going to wrap it up. We try to keep these webinars at about an hour. And speaking of webinars, Mark has put into the chat, we'll also send an email out of our next month's webinar. How governors are doing their state of the state. Well, us as pipeline fighters, we're going to do a state of the states. We're going to have state organizers come on from mostly the Midwest states to talk about what's happening in their state, what laws are being introduced, what the progress on those laws are, what the county level actions are doing. We have a pretty good summary, a wrap up of what states are doing, but the actual organizers are going to come on and update folks. So that'll be a good call. And then the month after that, we're going to dive down into the South and go down to the Gulf and talk to organizers down there about the progress that they're making in trying to stop some of these risky carbon pipelines and some of the other obstacles that they have. Charles asks, so is this a fair conclusion? Pipeline companies learned in their battles over oil pipelines what roadblocks occasionally were mounted, so they made sure that those roadblocks were not so easy to do in regards to CO2 pipelines.
I'm not sure that they they understood what the roadblocks were, the oil pipelines, and they adapted to those roadblocks to a degree. They didn't change the law so much, though. The law is still the same. They just figured out how to, manipulate the situation in different ways, hide certain aspects of their impacts. But the law really they haven't changed the laws related to the pipelines significantly. The regulations are still roughly the same, generally the same. So it's more that the oil companies figured out tactically how to, react to gain advantage of themselves. But, one of the things about nonprofit and citizen groups that I think an advantage they have over oil pipelines is the ability to react with great flexibility and creativity. So, if you can't strategically, you should never fight yesterday's battles, right? You need to figure out new ways of doing things, new approaches to these pipelines based on legitimate concerns about different sorts of safety risks and different needs for emergency response, agency emergency response activities. So, and in the past, counties and often were afraid to try to regulate pipelines because the oil companies come in and say they can't do a lot. Gradually the courts have said no, counties can, for example, consider safety and routing. And, but so the companies will tend to spin the law to their advantage, and gradually we're pushing back and making it clear that counties can do a lot. And with CO2 pipelines, counties seem especially willing to. Folks, farmers and ranchers have just figured out what a hassle these pipelines are for their properties, and they're demanding better protection locally and from the state governments.
Yeah, and that's exactly what they could and should be getting. We have lots of local zoning when it comes to windmills and solar. We should have just as much local zoning when it comes to pipelines. Connie asks, and I get this question a lot from landowners too, Paul, why don't the pipeline companies just install these pipelines in ditches or like current existing right-of-ways, like for transmission lines, for example, rather than using eminent domain on landowners?
Well, pipeline companies want to maximize their profits, and that means minimizing the cost of building the pipeline and minimizing the cost of operating the pipeline. And straight lines are cheaper to build and cheaper to operate. So the bottom line of why they're going to go straight across as they are is because it's cheaper for them, and therefore they're going to generate more profit in each barrel of carbon dioxide moved. Some places do require, or some states require, or can prioritize co-locating utilities. So for example, Line 3 in Minnesota went along some power lines for certain parts of its length, but not all states have that kind of rule. They generally wouldn't go into ditches, probably because it has to be 3 feet, 3 or more feet below the ditch level, and that could be a problem for the water drainage if they're digging up these ditches all the time. They generally won't go into roads because that would be they'd need right-of-way permits, and tearing up roads for very long distances is very expensive. So repairing roads is not a cheap proposition for them. So generally they just want to go point A to point B as short as the line as possible, and they just draw a straight line across the map, and that's why they go across your property.
Thanks, Paul. One of the most important things that I think as we wrap up for folks to remember is that, oh, go ahead, Mark, sorry.
I had one more question. I'm going to put Paul on the spot a little bit. I'm not sure if you are completely up to date on this, but was wondering if you could maybe summarize at least the preemption argument that landowners' attorneys are making in response to the counties, or not necessarily landowners' attorneys, but whoever is making the arguments essentially in these cases in favor of allowing counties and against the preemption argument. I know there's a brief that was filed in some of these cases, and I've seen that. I don't know if you could just kind of like summarize that a little bit.
Well, the legal arguments that are brought in any particular case depend on the ordinance. And, so for example, there's a case against Shelby County in federal court in Iowa, and the arguments there are going to be quite different than the case against Story County, Iowa, because the ordinances are very different. So it's hard to summarize what they are, in those cases, because it depends on the specific alleged violations by the pipeline companies, to how the pipeline companies allege that each ordinance violates the law. Evans County, South Dakota has a fee structure that they claim is excessive. Brown County, South Dakota has a pipeline moratorium in place that they claim is preempted. Again, each of these county ordinances are quite different, so there's a whole lot of different arguments that can be applied to them. There was an argument at the Iowa Utility Board in December on these preemption issues, and the issues there were: can the county consider, or state consider, IUB consider safety and routing, and also can they require disclosure of safety information for emergency response purposes? And I think that the briefing and the that was provided by landowners, by the Sierra Club, by the Office of Consumer Advocates, by the Farm Bureau, by all kinds of folks, was very good. And it blew the pipeline companies out of the water, because, the pipeline companies, some ways, it's like the emperor has no clothes. They make all these general broad assertions that, that state and county governments can do nothing. And when you look at the law at any level of detail, their arguments just disintegrate. Because the law doesn't say, the Pipeline Safety Act doesn't say that everything related to safety is preempted. A county emergency response plan is related to pipeline safety. It helps to improve the safety in the event of a pipeline rupture. But again, the Pipeline Safety Act doesn't allow PHMSA to regulate cops and police department or firefighters and emergency response. So when you get down to any kind of level of detail in terms of these preemption arguments, the pipeline companies' arguments often just, like the emperor has no clothes, just disintegrate. And so yeah, so it's not like, and again, they're also getting more and more federal court cases coming in confirming what state and county governments can do. But again, ask for an advice from an attorney when you're drafting an ordinance, because there are some needles you need to thread. There are certain kinds of things you cannot do, and you need to be very careful with how these ordinances are drafted to make sure they're not running afoul of federal law. And again, ask if you need some help.
Just one follow-up on that, thanks. And I was remembering the Iowa Utilities Board, because I knew the landowners had made the arguments, but I was kind of misremembering where. My follow-up was going to be, I'm looking in the chat here. The current rulemaking that PHMSA is doing, can you talk a little bit about that and how that relates to the moratoria that some of these counties are trying to enact? Sure.
So the Pipeline and Hazardous Materials Safety Administration, or PHMSA, recognizes that the CO2 pipeline regulations they have right now are inadequate. What happened back in '91 was that when Congress first said, hey, you're going to start regulating CO2 pipelines, the American Petroleum Institute came to the PHMSA and said, well, let's just have them be regulated exactly the same as oil pipelines. And PHMSA said, sure. So they just added the words "and carbon pipelines" to carbon dioxide pipelines, where the regulations currently say hazardous liquid pipelines shall do something. It says hazardous liquid and carbon dioxide pipelines shall do something. So they applied the same standards that are existed for oil pipelines to carbon dioxide pipelines. The problem with that is that supercritical carbon dioxide, is liquid carbon dioxide is very different from oil. It requires different engineering. It reacts differently in operations. The spills have very different effects. Oil goes into water, spreads all over the place. You have to skim it off the surface of the water and dig it out with backhoes. CO2 just goes into the atmosphere and spreads around and asphyxiates people. But yet, the rules for oil pipelines are exactly the same, with one minor exception, as they are for CO2 pipelines. And that means there's some serious gaps in the federal rules. They got away with it so far because most of the existing CO2 pipelines are out in Texas and Colorado, going up feeding the Permian Basin oil fields. And But now they want to build these carbon pipelines all over the country, including in, you know, much more densely populated areas. And they just simply haven't worked out. For example, what the danger zone should be around a CO2 pipeline in the event of a rupture. For a natural gas pipeline, they can calculate the blast zone, and if it explodes and burns, what the danger zone is there. For oil pipelines, they can figure out where the oil is likely to spread if it goes to any body of water. There's models for doing that. But for carbon dioxide pipelines, there are models, but no standard methodology to figure out if there's a rupture of a carbon dioxide pipeline, who's at risk. People ask me that all the time. It's like, I don't know. I mean, there are models that could be applied. There are methodologies to figure that out, but the federal government's never taken that on. And so PHMSA hopefully will look into that issue and figure out a way to say what the danger zone is. Then counties who have authority to route could look at that danger zone and say, well, we're going to keep the pipeline out of, away from schools and churches and hospitals and nursing homes and other sensitive facilities. So, there's a lot that needs to be done with regard to making the federal regulations much stronger and better than they are. And some counties, and like the state of California, and some counties and some state legislators are looking into saying, well, we're going to put a moratorium on pipeline development until PHMSA gets its act together, until they get their rulemaking done. And, that's certainly a viable policy option in many places, to say, we're not necessarily opposed to these pipelines, but if they're going to be built, we need to have adequate standards. And right now we know they're not adequate because they just sort of piggybacked on oil pipelines, 30 years ago. That doesn't cut it anymore. Let's do real regulations for these bad boys.
Thanks, Paul. I think my closing comment, and then I'll throw it to Mark and Paul to see what your guys' closing comment is. My closing comment after being in front of counties in states all across the Midwest and country is that the pipeline company usually sends in their consultants or their directors or their lobbyists to speak in front of counties or in front of our state elected officials. And they treat us like we're stupid, that we're a bunch of rural, rednecks that don't know any better, that don't know the difference between a federal law versus a county or a state law. And they just hope that if they give enough money to local nonprofits, promise enough jobs and enough tax dollars, that we will look the other way and not put common sense regulations on the books in the counties and at the state level. And that's really where you come in. Citizens, especially those who are living in these communities who would be most impacted, you're the ones who can force and really advocate at your local level to get proper regulations in place. And my argument always to county officials is we are doing this for wind and solar. We should do it for pipelines too. There is no reason why we can't have basic common sense regulations in place. We have plenty of sample ordinances or resolutions if counties need to press the pause button. BOLD is certainly here to help, as well as lots of good grassroots organizations all across the country. The only time that big oil wins and these big carbon pipelines wins is when we give up. And so we have to keep on pushing in order to make sure that our land is protected and our water is protected. And quite frankly, our communities are protected from this now new risk of these carbon pipelines, which obviously BOLD believes are really a big boondoggle and a climate scam. Paul.
Yeah, that's the strategy of the oil industry has always been to get people to surrender. We're the big oil industry, we're right, everybody else is an idiot. And so like with Nebraska legislature got, bamboozled into believing that and when they figure out a route for oil pipelines that they can't consider safety. So Nebraska's legislature wrote into law that, the government can't consider safety when it's routing a pipeline. Well, like I said, that was back in 2012 or something. And, since then there's been 3 federal courts, and the federal courts get to decide what federal law means, not state legislators. So those 3 federal courts that have now said that looked at situations where local governments considered the location or route of a pipeline facility, considered safety as part of their decision-making process for that facility, and then either reroute the pipeline or denied a pipeline permit based on that safety risk. and the federal court said, consideration of safety in a routing decision is within, it does not make that decision a safety standard under the Pipeline Safety Act. So, the courts have slightly different reasoning for all those arguments, but they're consistent with each other. And again, the federal courts get to have the final say in what a federal law means, not a state legislature.
Mark, do you have any closing comments?
I just had one follow-up question. Do we know when the PHMSA rulemaking is expected to be completed? I feel like I saw some industry chatter on that, but Paul, do you have any idea?
Yeah, the rulemaking process under federal law requires that they first issue a notice of proposed rulemaking, and that's a draft regulation. That's PHMSA said it's going to come out, I believe, in October of this year. And then, the very fastest that ever goes is 6 to 9 months. And they would take in comments from that proposed rulemaking. They would rework the regulations and then issue new what's called final rule, which is the final regulation. And that gets published in the Federal Register, and then it gets put in the Code of Federal Regulations. And ideally, that whole process, once the most proposed rulemaking comes out to the final rule, like I said, would take, could take as little as 6 to 9 months. In practice, it can take years. And even once an agency comes out with its final rule, it can be challenged in court, which the pipeline industry typically would be expected to do. So as much as we'd like to say that the federal PHMSA process will be finished by, say the summer of 2024, it could be a year or two later than that. And if it gets into court, it could be the end of this decade, truth be told. I mean, there have been PHMSA rulemakings that have taken 10 years to complete. And, but again, I think it's important to, even if that's a risk, it's important to advocate for it, because they will come out, these pipelines will continue to be built. And, political pressure can be brought on the companies to not sue, and for this process to move ahead, so it doesn't just get bogged down. So, it's important, if people want to do a moratorium, that would put pressure on PHMSA to get it done, and put pressure on the companies not to drag out the rulemaking process through litigation.
Thanks. It's a great follow-up. The only other things I had were a reminder: next month, State of the States. We'll have the registration link along with all of the links that I put in the chat. Y'all will be added to the Pipeline Fighter Sub email list. You'll get a recording of this program, and on the page with the recording, we'll have all of the links that I put in the chat today. That's all we have. Thanks, everyone. And hope to see you next month.
See everybody. Keep on fighting.